Okay, this is a very packed day. The next coming days will be a little less hectic, um, but we're honored to have Corrie Manning, who is the General Counsel of the California League of Cities, and Betsy Strauss, who is, let's see, Betsy, looking at her formal title, but she's basically with ILG, I guess is what I would say, right? Is that right, Betsy? Where are you?
She's actually our special counsel.
Okay.
So she's been my right hand woman lately.
Oh, great.
We'll just call her that.
We work, just a little bit of background. We work very closely with the California League of Cities and with Corrie. You're going to be hearing later in the week from Dane Hutchings, who is the head of our policy group, who also worked at the California League of Cities until not too long ago. Our relationship with the league is multifold, I guess I would say. One is that they engage in legislative advocacy for issues we care about. I will say that very often takes the form of fending off. The watchword is, well, it could have been worse. And then also, we work with Corrie a great deal on litigation and somewhat on legislation as well. And we write amicus briefs for the league. We prepared the amicus brief for the league we've done a lot of them, but the biggest one that I was involved in involved pension vesting, the Cal Fire case, which was a really major effort, and they took a terrific lead on that issue. And I know we did a amicus brief very recently on a Brown Act issue as well. In any event, Corrie has been a wonderful sort of comrade in arms on the issues of, well, a lot of different issues, but one of the issues, and the issue we want to talk about today a little bit, is kind of local control and cities. Where do cities position themselves vis-a-vis the state and regional issues, and some of the challenges that really arise out of that. I mean, I will say up in front of this, although I reserve my right to change my mind after Betsy and Corrie get done. I have always viewed myself as, coming from San Francisco, a real diehard local control fan, because a lot of the freedoms that San Francisco has experienced in terms of the ability to create policy that meets our needs has to do with the fact that there was local control. And yet we face these tremendous challenges in the areas of, for example, housing. You heard Mayor Brown mention homelessness, that at a minimum demand regional solutions, and where local control can be kind of a pain in the ass. So so Betsy and Corrie are gonna, I'm gonna hand it over to you guys. They're gonna give you sort of the intellectual foundations of this and some of the practical challenges as well. And we can't thank you enough for participating. I guess maybe why don't we just go around the room for a second and have each fellow just introduce themselves and what school they're at. We'll start with Heba. I'm looking for whatever order we got.
Good morning. My name is Heba, and I'm a rising 2L at UC Davis School of Law.
Michael.
Good morning. I'm Michael. I'm at UCLA Law. I'm a 3L.
Susanna.
Hi, Hi, good afternoon. I'm Rising 3L at Hastings.
Jake?
Good afternoon. Also Rising 3L at Hastings.
Allison?
Hi, I'm Allison. I'm a JD MBA student at Yale and Yale Law School and Stanford Graduate School of Business.
Kelly?
Hi, I'm Kelly Beskin. I'm a Rising 3L at UC Davis.
Garvey?
Hello, my name is Garvey. I'm a Rising 3L at UC Hastings.
And Peter?
Peter, I just graduated, I guess, 3 weeks ago from Yale Law School.
So we're very, very proud of this group of folks. Mayor Brown just spoke, and they had, I thought, terrific questions for him. I almost wished we had more time to delve into them. But anyway, thanks again for being here, and let's take it away.
Great. Thank you so much, John. And I'm really excited to be here today with you all. As John mentioned, I'm the General Counsel for the League of California Cities, and I'm joined by Betsy Strauss, our Special Counsel. I'm going to do the majority of the presenting today, but I've asked Betsy to be on here, and I'm going to invite her to chime in with comments and fill in any of the holes I might miss as I'm going through my presentation. Just because you all just shared your own backgrounds, I'll just share that I went to UC Davis for my undergraduate degree, and then I graduated from George School of Law in Sacramento. And I was in private practice before I came to the League a little over 5 years ago. I started doing labor and employment litigation, and then now that I'm with the League of California Cities, I do pretty much anything that involves a legal issue that a city faces. So it's been a really interesting career transition for me, and I look forward to talking with you all today about home rule. I thought I would, John gave you a little bit of an introduction to the League of California Cities. I thought I would just elaborate that on that quickly. So we are the association in California that speaks collectively on behalf of our member cities, and nearly all cities in California are members of the League. There's 482 cities, and I think there's only 3 cities currently that are not members of the League of California Cities. So we really are the entity that speaks collectively in conversations with the legislature right now in the midst of the COVID-19 pandemic. We've been having direct conversations with the governor and his administration as cities navigate this crisis. And in addition to being an advocacy organization, we're also an education organization. So we educate city officials and city leaders so that they can be the best local government stewards they can be, and we take that really seriously, and we all really enjoy doing this work at the League of California Cities. So this is our agenda for what I'm going to cover during our presentation today. We're going to start off by talking about what are cities, and that might seem silly and basic. You might be thinking, I know what cities are. I don't know why we have to touch on that. But I think when you take a step back, you might realize, maybe you've never really thought about where do cities derive their authority and power from, and how do they go about exercising that authority and power. I want to touch a little bit on some demographics of cities in California to give some context for our conversation about home rule, and then also touch on the 2 types of cities in California, which are charter and general law cities, and what the differences between those cities are. Our next topic will be talking about what is home rule. We'll talk a little bit about how the doctrine came about, the text from which this doctrine derives, and we'll talk about where the doctrine is today. It's evolved a lot over the years, but we'll talk about a few cases and really dive into how the courts are currently applying the home rule doctrine. So during the discussion portion, we'll do a little more in-depth discussion of some cases there are a lot of home rule cases in California construing the home rule provisions of the California Constitution. We obviously won't have time to get into all of them today, but I've picked out a few topics that I thought would be interesting for discussion today. Decided in light of current events that I'll touch quickly on home rule in the police context, and then I also want to talk about prevailing wage, elections, and housing. And then finally, we will end with questions and opportunity for further discussion. I also just want to encourage any of you as we're going on, if you have a question, feel free. I want this to be a conversation. So, if you want to interrupt and ask a question, I'm certainly open for that. So don't hesitate. Okay, next slide. So what are cities? Talking about the authorizing law for cities, first and foremost, cities derive their power from the California Constitution. So when California became a state back in 1850, the Constitution authorized cities to have power, but the original Constitution vested the state legislature with the exclusive power to establish cities and to enlarge or restrict city powers. So back when the state Constitution was originally created, cities had to have authorization from the state legislature in order to act. So this persisted for about 30 years, and during that period of time, there was state meddling in city affairs. This is probably not surprising, and this was really ill-perceived by the public in California. And so in 1879, the California Constitution was amended, and now cities have inherent powers vested in the California Constitution. So they derive their powers directly, and they do not need legislative authorization for local acts to protect the public health, safety, and welfare of their residents. So cities were essentially freed to adopt local laws on their own without needing to go to the legislature. And in today's Constitution, that provision is codified in Article 11, Section 7, which grants what are known as broad police powers to cities to govern for health, safety, and the welfare within their local jurisdictions. The California Constitution does provide that the legislature shall prescribe uniform procedure for city formation and provide for city powers. So that's in Article 11, Section 2. So state law does still essentially provide the procedure for cities to form, and that specific state law is the Cortez-Knox-Hertzberg Local Government Reorganization Act of 2000. So the government code establishes the procedures for local governments to form. So essentially what happens is the state of California is divided into 58 counties, and the cities that exist today were incorporated within those counties, but there are still areas of California that are considered unincorporated areas. So there are areas of those 58 counties that have not been incorporated into cities. And so I think the most recent city was formed in 2011. So essentially when an unincorporated area decides that they want to form and become a city, they follow the process set forth in the state statutes. And ultimately, once they've followed that process and checked all the boxes, they have to get majority voter approval in their jurisdiction to form that city. And once they do that, the responsibility for governing in that area essentially shifts from the County Board of Supervisors to the newly established City Council. So moving to governance, general law cities are formed in accordance with the state general laws. So their governance has to follow what is set forth in state statute, which includes that general law cities have to have a city council of at least 5 council members, And then they can choose between a city manager or a strong mayor form of government. So the differences between those are, in a city manager form of government, an elected council of the city essentially hires a city manager who is not an elected official, and that person becomes responsible for the day-to-day operations of the city. And that person can be hired and fired by the city council, but they themselves are not an elected official. In a strong mayor form of government, the mayor acts as the city manager would act, managing the day-to-day affairs of the city. And the difference there is, of course, the mayor is an elected official. So in order for a change to be made, it would have to be made by the electorate. They would have to decide, you know, we don't like what this current mayor is doing, so we're going to vote this mayor out of office, rather than with the city manager, you have the politics of the day-to-day operations of the city are a little more removed because the council hires and fires that city manager. A note on demographics. So I mentioned there's 482 cities in California. I've put a little graphic into the slide here, and what this shows is population density in California. So it's interesting, you know, you can see that the areas of dense population are actually pretty small areas of the state. Most of the state of California does not have such dense populations, and they tend to form around the coastal areas, a little bit in the Central Valley, but obviously the Bay Area and the LA area and San Diego area being the most population dense parts of California. Out of the 482 cities in California, approximately 400 of them have population less than 100,000. So it's another interesting fact. You know, the greater populations are actually concentrated in a smaller number of the cities in California. And then finally, I believe that 121 cities in California are currently charter cities, although as I was preparing for this today, I saw something that said that there were 122. So I could be a little behind on my numbers, but that's our latest number that we have at the league, and we'll have to see if we're up to date on that. Okay, so next slide, please. So there are two types of cities in California: general law cities and charter cities. There's one exception to this general rule, and that's the city and county of San Francisco. San Francisco is a consolidated city and county. But I would say, for purposes of the analysis we're going to walk through today, they're likely to be considered more like a charter city. They do have a charter in San Francisco. General law cities are cities that have not adopted a city charter. So general law cities are governed by the general laws of the state, and their powers are derived, as I mentioned, from the state constitution, Article 11, Section 7, and also under state law. So general law cities, based on that constitutional authorization, are free to legislate on matters unless they conflict with a general law of the state. And in that circumstance, the state law would be preemptive of the local law. Charter cities are a little bit different. So charter cities that have adopted a charter with the approval of a majority of city voters have greater powers under the California Constitution. So the authorizing law for charter cities is Article 11, Section 3 of the California Constitution. Basically says that cities can become a charter city if they adopt a charter and get majority vote approval in their jurisdiction. The procedures for adopting a charter are set forth in state statutes. So either cities can elect a charter commission to draft their charter, or the city council can draft the charter. But again, it ultimately has to be approved by a majority vote of the people in the jurisdiction. To amend, revise, or repeal a charter, the process is the same. You need a majority vote to be able to do that. However, what's a little bit unique about this is that can be done by initiative. So the city council can put something on the ballot to amend or revise or repeal a provision of the charter, but the people can also do that through the initiative power. It's often said that once a charter is adopted, it operates as a constitution for the adopting city. And I just want to make a little note about that. So unlike the federal constitution, which is a grant of authority, so as you know from your law school instruction, Congress cannot do anything unless it's authorized by the federal constitution to do that. The California Constitution is actually a limiting document. So the California legislature has inherent authority to adopt laws governing the people in California, and the Constitution is a limiting document. Charters operate the same way. Charters are limiting documents. So cities derive their constitutional authority from, or they derive their authority from the Constitution, and their charter can be a limit on their ability to exercise that authority, but their authority to adopt laws for their local citizens actually derives from the Constitution itself, even if they are a charter city, although you do need to look to the charter to understand what the limitations are of their powers. So, okay, next slide, please. So let's talk about home rule. We'll talk a little bit about the origins. So I mentioned that the first state constitution in California gave the legislature the exclusive power to establish cities and to provide for city powers. And I mentioned that, you know, this dominance over cities by the legislature was ill-perceived, and that was because of certain abuses that were going on. So for example, the legislature during that period of time sometimes appointed special commissions to manage the municipal property and funds of certain cities. So they might do something like pass a law that would direct cities to spend their money in a specific way. Kind of the well-known example of that was a law that the legislature passed in order to require the city of Stockton to spend a significant amount of money on construction of the railroad. And these were the types of actions by the state legislature that led to the Constitution when it was amended in 1879 to changing that so that cities inherently were granted their own powers. And this is what has commonly become known as the home rule power. So during that constitutional convention in 1879, the delegates to the convention looked to actually the state of Missouri's constitution. They were the first to include this authorization for home rule by cities, and California borrowed some of those provisions. And their intent was that cities should be able to do what they need to do in their local jurisdictions for their local communities, and they shouldn't be restricted in their ability to legislate locally, except within the framework of the state's general laws. And so that's what is set forth in Article 11, Section 7. And then this 1879 constitutional revision created these broader powers for charter cities. So they added provisions that allowed for the creation of charter cities, as we just discussed. And then they also added what is now Article 11, Section 5, which grants authority to charter cities over municipal affairs, and even goes so far as to say charter cities have authority over municipal affairs, and that means that they can actually adopt laws that conflict with the state's general laws. The only limitation on that is whether the state law pertains to a matter of statewide concern. And if it pertains to a matter of statewide concern, then the state law can still preempt those local laws. And this is kind of the crux of the discussion we will get into and how courts have applied those rules. So next slide, please. Oh, I'm sorry. Can you go back to that slide? Sorry. I was going to take a moment. I actually think it's helpful before we kind of get into this conversation, and I apologize for reading to you all because I know you can all read, but I think it's helpful to have the actual constitutional text of these sections of Article 11 fresh in our mind as we talk about the application of the Home Rule Doctrine. So Article 11, Section 7, it's a very short provision. It simply states, a city may make and enforce within its limits all local, police, sanitary, and other ordinances and regulations not in conflict with general laws. So that's the basic grant of home rule authority to cities. And it's important to note that general law cities also maintain that authority. There's a common misperception that only charter cities possess home rule authority, but general law cities also possess home rule authority. It's just that general law cities are bound by state general laws, even with respect to municipal affairs. So if there's a conflict between a local law of a general law city and a state general law, the state general law is going to prevail. For charter cities, that's a little bit different. So let me read the language of Article 11, Section 5. There's two subdivisions of this section. Subdivision A states, it shall be competent in any city charter to provide that the city governed thereunder may make and enforce all ordinances and regulations in respect to municipal affairs, subject only to restrictions and limitations provided in their several charters, and in respect to other matters, they shall be subject to general laws. City charters adopted pursuant to this Constitution shall supersede any existing charter, and with respect to municipal affairs, shall supersede all laws inconsistent therewith. And then subdivision B goes on to say, it shall be competent in all city charters to provide, in addition to those provisions allowable by this Constitution and by the laws of the state, for one, the Constitution, regulation, and government of the city police force, two, sub-government in all or part of a city, three, conduct of city elections, and four, plenary authority is hereby granted, subject only to the restrictions of this article, to provide therein or by amendment thereto, the manner in which, the method by which, the times at which, and the terms for which the several municipal officers and employees whose compensation is paid by the city shall be elected or appointed, and for their removal, and for their compensation, and for the number of deputies, clerks, and other employees that each shall have, and for the compensation, method of appointment, qualifications, tenure of office, and removal of such deputies, clerks, and other employees. So that subdivision B sets forth some examples of areas that were specifically contemplated as municipal affairs when this provision was added to the California Constitution. Okay, we can go to the next slide now.
You have a question. Do you want to take it now or do you want to wait?
Sure.
Okay, Peter, go for it.
Let's.
Hi, I'm sorry if you were going to touch on this in the coming minutes, but I was just curious if I were a group of citizenry wanting to form a city, why I might opt for a general law city rather than a charter city, just thinking about wanting a little more legal armor against state interference.
Yeah, good question. You know, I think initially a lot of cities were created as general law cities. That might not necessarily be true about all cities, but then the question of adopting a charter becomes, do you want to have a document that kind of sets out the authority in that particular city? So kind of a pro of having a charter is, as you said, you get these additional protections for your actions. You get additional protections with respect to municipal affairs. A con of adopting a charter is that there are those stringent procedures that I talked about for amending the charter, and also the ability of, you know, the initiative process to change the rules that govern the the city council, essentially. So that's, you know, kind of the countervailing considerations. I think a lot of times cities that are currently general law cities and are thinking about becoming charter cities, you know, there's also a challenge in educating your electorate on why you want to become a charter city, because you have to have majority voter approval to be able to do that. Of course, there's, you know, costs associated with that. So those can become a barrier to current general law cities becoming charter cities. But in terms of their additional authority, becoming a charter city really gives you that extra argument, and we'll kind of talk a little bit more about what that looks like when a city is involved in litigation.
And Peter, just one quick note on that. I have said for the longest time that, you know, we should write a 3-page charter that any city could adopt by filling in the blanks. You know, and it continues to some extent to mystify me to this day why people don't do it. But anyway, it's
Great, thank you so much.
Can I have one more thing about an answer to that question? In days gone by, I think the two principal reasons that a city would be a charter city, and like you see the big cities in California are all charter cities, was for financial reasons, that a charter city had far more financial independence and financial revenue raising and expenditure authority than a general law city. That's all gone by the wayside, you know, in the last 30, 40, 50 years. And also in the governance structure, right? So you see in charter cities, a variety of city councils with a variety of numbers of people. You see strong mayors that have much more authority than a mayor in a general law city. And so there are some sort of structural reasons to be a charter city. And then I think in large part, as I say, many cities became charter cities because they had more financial independence.
Thanks, Betsy and John. Okay, so we'll move on to the next slide.
Question, I think, but I'll go to the next slide as well. But Michael, I don't know if you want to ask your question real quick.
Oh yeah, sure, thanks. Betsy touched on this a little bit, but is there a relationship between population density and charter city status? I mean, are more population dense cities, do they tend to be, and we were just speaking about population density earlier, do those cities tend to be charter cities?
I think the answer is yes. I haven't, you know, overlaid them, but I think the answer is yes. The more populated cities, like Los Angeles is a charter city, San Francisco, you know, I said it's an exception, but it's a charter city. San Jose is a charter city. So yes, I think the more densely populated areas tend to be the charter cities, although you know, I think there are also some charter cities that aren't as densely populated. Okay, so next we'll talk about some limits on the home rule power. So we've kind of talked about home rule being this broad grant of authority from the California Constitution for cities really to control locally what's best for their communities, to make the laws that make the most sense for their communities. And in charter cities, you know, as we were saying, even that extra grant of charter cities have supreme authority over their municipal affairs. And cities that have adopted a charter have essentially said that through the majority vote approval process. You know, we want to make the decisions about what goes on in our community. But there are some limits to home rule, and I want to spend most of our time on the judicial limits and the home rule doctrine as it's been developed and interpreted by the courts. But before we go there, I wanted to just touch on 3 other items that I think are interesting and should be of note. So the legislature operates as a limit on municipal authority. And the way they do that is, the legislature, they know what the rules are when it comes to home rule power and what's provided in the Constitution, but that really doesn't stop the legislature from trying to encroach upon municipal homeroom power and interfere in local matters where they feel like they have an interest at the state level that should trump local regulation. The legislature, I think, also is, I feel pretty confident in saying that the legislature at the state level fears the idea of cities gaining too much power and having too much local autonomy. And I think the fact that, when we get into the courts and how they've interpreted the home rule provisions, you'll see that the courts, even though there is this very strong grant of local authority, the courts tend at the end of the day to, if they can find a statewide concern, they're going to find a statewide concern, and they just generally seem to side more often with the state than they do with the local government. So the legislature has every incentive to, try to push the limits of their authority. Another limit is a financial limit. So, we all know that you need money to be able to do things. And so for cities to accomplish their local objectives to provide services locally, they need money to be able to do what they want to do in their communities. And earlier on in the creation of California as a state, cities enjoyed much greater autonomy and flexibility when it came to their local finances. But over the years, and based in part on initiative measures, starting with Prop 13 in 1978 and continuing even until 2010 with the passage of Prop 26, there have been significant limits placed on property tax and sales tax revenues of cities, and also limits on their ability to adopt local taxes. Now in the California Constitution, there are several procedures that they have to follow in order to take revenue raising measures locally. And so these limits on cities' ability to raise revenue has a significant impact on cities' ability to do things locally. And I'll just mention quickly here, there was one of the kind of seminal decisions in the area of home rule is a decision where the city of Los Angeles had a municipal tax on savings and loan institutions, and there was a question put forth to the California Supreme Court on whether they could charge that tax because state law essentially provided for its own tax, and that was supposed to be in lieu of all other taxes that were charged. And that decision, the Cal Fed decision, essentially became one of the earlier decisions pertaining to home rule. And even though the Supreme Court acknowledged municipal taxation as a municipal affair, it still allowed the legislature ultimately to limit the city's collection of that tax in that case. So we're talking about a power that the court admits is a very important local power, but they still allow that power to be infringed. And I think that's a theme you'll see as we talk about some of these other cases. And then finally, I just want to mention quickly the initiative power. The fact that local decision-making can be overridden by people through initiative, does provide a limit to what can happen locally. And oftentimes, sometimes it may be the local residents who, come up with this idea and decide, oh, we want to override what our city has done locally. But in other circumstances, there's other special interests behind that effort. And so it's another way that people can limit the power of cities to do things locally. So getting into the judicial limitations on home rule. So we've talked about the home rule grant lives in Section 7 and Section 5 of Article 11. The analysis when we're talking about when we have a case where a local law is being challenged as not being authorized because there is a state law that conflicts with the local law, the analysis actually starts in the same place under both sections. So, you know, again, cities have this broad constitutional power to regulate locally, as long as the local regulation that they've adopted has some rational basis for, you know, some tie to protecting the health and safety of their local community. That's really all they have to do. But what happens when that local law comes into conflict with a law at the state level? And so that's the second step in the analysis. If a conflict exists between the local legislation and the state law, then we have to do analysis of whose law governs in that situation. And conflicts can exist in one of three ways. Either the local legislation can duplicate, so it could say exactly the same thing the state law says, in which case it becomes an issue of jurisdiction. It could contradict the law, so perhaps it's not possible to comply with both the local law and the state law, and that would be a prime example of a contradiction. And in fact, if it is possible to comply with both, the court is going to lean towards finding no conflict. And then finally, there could be field preemption, essentially. So if the state has occupied the field of a certain area of law, then that could create a conflict. So courts are actually reluctant to infer legislative intent to preempt local laws. So the intent to preempt has to be pretty clear. If the legislative intent is clear or expressed, if the legislature specifically says in this law that their intent is to override any local legislation in this area, courts will afford great weight to that, but it's not determinative. So it's not sufficient for the legislature to just say, we are preempting local authority in this area. Courts still have to do the analysis of whether what's at issue is truly a municipal affair rather than a matter of statewide concern. And for charter cities, there's an extra step in the analysis, because even if there is a conflict, as we talked about earlier, charter cities enjoy authority over municipal affairs. So if the matter pertains to a municipal affair and it's not a matter of statewide concern, then the charter city's law will govern, even though it might conflict with a general law of the state. The trouble with this doctrine comes from the fact that there just really is no real definition of what is a municipal affair and what is a matter of statewide concern. And courts have acknowledged that in the case law. There's, I forget which case it was. It was a case that predated the CalFed case, but there was a justice that called the words municipal affair wild words, because it's just, we're not sure exactly what they mean. We talked about Article 11, Section 5 and Subdivision B, and the fact that they set forth specific categories of municipal affairs. But if it's not one of those categories, you know, how do we determine what is a municipal affair? And then once we have determined what is a municipal affair, how do we decide that there's actually a matter of statewide concern that overrides the local authority over that issue? So I want to jump in now. If we could go to the next slide, please. I think it will be helpful if we kind of talk about some of these specific cases, some of these examples. And I decided I wanted to talk about the issue of police. I don't know how many of the rest of you saw this, but it caught my eye and made me think about, you know, that I was going to be talking with you all today. But President Obama, you know, in light of the civil unrest throughout the country, had tweeted out I guess I'll call it an article, and it was about how to make this moment a turning point for real change. And in that article or that statement that he put out, he noted the importance of local government. And he pointed out, you know, so often people focus on federal government for to make changes in this area, but local governments are really the ones who have a lot of control, especially in the police sphere. So, you know, local city councils or county boards of supervisors, they're going to be the ones who are appointing the police chief, or you know, there's going to be an elected district attorney who decides whether to charge police officers when there is an excessive use of force with a crime, you know, those types of things. And so it got me thinking that I wanted to kind of touch on that today. So I'm going to talk about the case of Baggett versus Gates. And in this case, there were the plaintiffs were police officers who were suspected of engaging in misconduct while they were on the job. So there was an allegation that they were drinking on the job, they were tampering with evidence, they were, you know, using things like explosives to play pranks and things like that. And so the department conducted an investigation. Based on the facts of the case, the investigation wasn't really all that thorough or complete. But ultimately, they decided that they were going to demote these police officers. And it wasn't because they sustained the findings of the investigation. They just said, you know, we have this ability to demote these police officers, so we're just going to go ahead and do that. And the officers said, wait a second, we have rights under the Peace Officer Bill of Rights. So there's a state law in California, the Peace Officer Bill of Rights. It guarantees certain rights to police. It secures protections for them when they are subject to interrogations that could lead to punitive action. It gives them the right to review and respond to adverse comments in their personnel file. Gives them the right to file an administrative appeal when any punitive action is taken against them. So in this case, they were asserting we should have the right to appeal our demotion. And what the city was saying was, no, we're a charter city and you don't have the right to do that because the conduct of the city police force is an enumerated municipal affair under subdivision B of Article 11, Section 5. So the question in the case was whether the charter city had the authority over the or the ability to demote these police officers without complying with that state law. And ultimately, the court found that the state law what did need to be applied because, and this is kind of one of the cases in which the court drew a procedural versus substantive distinction between the law. So the court said, look, we're not telling you that you ultimately can't demote these officers. What we're telling you is that there's this state law that guarantees certain protections to police officers, and you need to comply with that law in order to, you know, arrive at your ultimate decision. And the support for that, what they found as the support was that the intent behind the Peace Officers Bill of Rights was to secure basic rights and protections to a segment of public employees who were thought unable to secure them for themselves. So that was kind of the legislative, that was asserted as the legislative intent for the statute. And the court in that case said, when a matter is of concern to both cities and the state, the question is whether the matter is of sufficient statewide concern to justify a new legislative intrusion into an area traditionally regarded as strictly a municipal affair. Such doubt, however, must be resolved in favor of the legislative authority of the state. So this is, you know, we're talking about how courts tend to resolve things in favor of the state. This was an example of that, and again, also a case where we started to see this procedural versus substantive distinction over whether a state law actually impacts the authority of the local government, the municipal affair authority, or whether it's just something procedural that maybe they have to comply with, but ultimately at the end of the day, they retain the authority to make that decision. Before I move on, are there any questions, or Betsy, did you want to chime in on anything on that?
Happy to hear questions, and no, I don't have anything to add.
Let me just understand
Okay,
one quick point there. I mean, it's as you said, it's a wild words problem that it's kind of all over the map, and I guess that you know, the real challenge here is that the home rule doctrine seems only as good as the will of the state to override it in some respects, and yet it sort of does, nonetheless, from time to time, get reaffirmed by the Cal Supreme Court, as in the Vista case. So I guess the question is sort of, is there any method to their madness on this issue at all?
yeah, so actually I was going to cover the Vista case next, so let's turn to Vista. Good segue. So the Vista case involves prevailing wage, and in 2007, the city of Vista decided to switch to a charter city, and actually the ballot materials for the city voters voting on whether Vista was going to become a charter city explained that part of the draw of becoming a charter city was that the city would enjoy greater autonomy over their municipal affairs, including deciding if they would pay prevailing wage on local public projects. And just to be clear, everyone's on the same page. Prevailing wage is a basic hourly rate paid to workers, and it's determined by the Department of Industrial Relations. It's exactly what it sounds like. The prevailing wage is kind of like the common denominator of what the wage is in that area and in that industry. And a lot of times it's a pretty high wage. And so so the city put this forth before their voters, said, you know, if we make this change, if we become a charter city, we will gain greater autonomy over our public projects. We can make the decision, essentially, if we want to pay prevailing wage or not. And so the voters approved that charter amendment, and then after they became a charter city, the council approved a project to build 2 fire stations in the city, and what they approved for the design and build of those 2 fire stations did not call for the payment of prevailing wage. So the union, the State Building Trades Council, sued the city of Vista, saying that payment of prevailing wage was required by state law, by the labor code, which requires the payment of prevailing wage on public works projects. And the case made its way up to the California Supreme Court, and the California Supreme Court noted that in order to decide the case, they had to decide how the state constitution allocates governmental authority between charter cities and the state. And so ultimately what they found in this case, they did the 4-part analysis. So, and I might have glossed over that earlier, so let me go back to it. So the first question is whether the 4-part analysis for a charter city is whether the city ordinance pertains to a municipal affair, or the city action pertains to a municipal affair. And if it does, which here it did, because we were talking about payment of workers, then the next question is, is there a conflict between the municipal law and the state law? And again, here there was, because the city was saying, we're going to build this public works project and we're not going to follow the state law requirement that they pay prevailing wage. The next question becomes, does the state law address a matter of statewide concern? And here the court concluded that it did not address a matter of statewide concern. And ultimately they found that paying wages for a project that was going to be conducted within the city, done with city funds. You know, that truly had to be a municipal affair. There was no dimension that made it what they call extramural, or something that goes outside of the city. We were talking about a city-specific project. Let's see, there was a quote from the case that I wanted to read here. So the union, in counter to that, they said that what the statewide interest was, what they argued the matter of statewide concern was the interest in labor relations and vocational training for, you know, this particular industry. And the court said that can't be the way the question is framed. The court said the question presented is whether the state can require a charter city to exercise its purchasing power in the construction market in a way that supports regional wages and subsidizes vocational training while increasing the charter city's costs. So rather than looking at what the union alleged was the statewide concern, which, you know, the court acknowledged, yes, there is a statewide interest in promoting stable labor relations, and there is a statewide interest in vocational training. However, what they were trying to do here was direct the city in how they were going to use their particular funds. And the court said they cannot do that because the way the city wanted to have this project built was a municipal affair and did not rise to a matter of statewide concern. What John probably wanted to get to after all this is, so that was a great victory for charter cities. Well, not long after that, the state legislature, in direct response to this litigation, they decided, well, if we can't directly tell charter cities how to spend their funds, we're going to pass a law that essentially says, okay, if you're not going to pay prevailing wage, if you're not going to follow the state law and do what we want you to do, then you are not going to receive state funding for these projects or even for any other projects. So they passed a law that said that if a charter city built a local project without paying prevailing wage, then they would be ineligible for state funding. And the league was involved in a legal challenge to that law, but ultimately the legal challenge failed, and the court said the state has a prerogative in how it spends its money. And even though that seems coercive, because it's essentially saying, you know, you have to pay prevailing wage, otherwise you're not going to get state funds, the court said that was okay. I know I'm running up against my time. Is there something after this, Madeline, or?
No, just the question slide. So I don't know if you have the time to take a couple questions or if you have a hard stop. It's kind of up to you at this point.
Corey, could I
I don't have a hard, sorry. Go ahead, Betsy.
Sorry, Corey. I was just going to try to take a stab at answering John's question about can we make any sort of general conclusions about these cases, which are, as Corrie has said, are very difficult to reconcile with each other. And so I just like to try to do that. I don't know that it actually works, but this is what is on my mind about this today. The courts seem to be making a distinction between state laws, which tell charter cities how to do something, you know, the procedure for doing something, and state laws that tell charter cities exactly what to do. So in this Baggett versus Gates police case, where they say, wait a minute, you can't transfer those officers to another unit without allowing an administrative appeal, the court's saying, hey, just allow the administrative appeal. We're not telling you how to rule on the appeal. We're not telling them you ultimately not to transfer the officers. We're not telling you your investigation was no good, just allow the appeal. It's just a process, you know? And then in a case that I know John is very familiar with about minimum wage, you know, the court says, wait a minute, we're not actually telling you what to pay city workers when we say the state minimum wage law applies to city workers. We're saying this is just a minimum. This is just a minimum. You can pay them whatever you want. On the other hand, in City of Vista, they're saying you must pay the prevailing wage. And so that is like what you must do, not how to do it. You know? And so another case that I think, Corrie, maybe you'll still talk about this housing case, Anderson versus the City of San Jose, where the court likewise says, we're not telling you who to sell your land to. We're not telling you what housing to build on it, but we are saying this is the process you must follow, Charter City, when you sell your land. So this is my current theory, that the courts distinguish between process and substance. And when they see process, they go like, oh, that's just process. You can do that. We're not telling you what to do. And then when they see like, we are telling you exactly what to do, which they don't find that very often, but when they do find it, like in Vista, they say, no, this doesn't work. This is not a matter of statewide concern. You've gone too far.
Thanks, Betsy. That was really helpful. And if we do have a couple of minutes, I would like to touch really quickly on that Anderson versus City of San Jose case. And if you all have not read it, I would encourage you to read it. It's a very recent case. It has to do with the Surplus Land Act, the state law that essentially says that local governments, when they sell off their surplus land, they have to prioritize that land for affordable housing. And there's you know, several aspects of that law. We don't need to get too deep into them. But the City of San Jose, which is a charter city, they adopted a local ordinance that essentially followed state law for the most part, except for a few distinct categories where they said, you know, okay, sure, you know, we also believe in affordable housing. We want affordable housing in San Jose, but there's just a couple areas where we have surplus property that we don't think it's appropriate for it to be used primarily for affordable housing. And so they exempted certain areas in their downtown and kind of reserved their rights to do something different in a particular case. And they thought they were on pretty solid ground because that's their property, right? That's the property that they own. It's their surplus property. And they thought, as a charter city, what we do with property we own, how we dispose of it, has to be a municipal affair. And ultimately, that was challenged. And like Betsy just said, the court drew the distinction that the court drew was they were saying that, you know, we're not telling you ultimately what you have to, the end goal of what you have to do with this property, although there's been some recent legislative changes that maybe would change that analysis, but we're not telling you exactly what you have to do with this property ultimately. We're just saying, in order for you to get to the point of selling your surplus property, you have to follow these steps first. And there is a noticing requirement. You know, they have to let people know that the property is available so that it can be used for affordable housing. There's provisions in the law that require a certain number of affordable units if the property is ultimately developed in a particular way. And so the court did draw this procedural and substantive distinction, although Betsy and I have had many conversations, and the league actually supported a petition for review to the California Supreme Court on this case, which was ultimately denied. And I think, you know, setting aside kind of the court's conclusion in that regard, which I think we could talk about whether or not that was the right conclusion, I did want to take a moment to talk about kind of the last part of this test. And essentially, there is an additional component that even when there is a matter of statewide concern, the matter of statewide concern has to be reasonably related to the matter of, or the legislation has to be reasonably related to that concern. And it doesn't have to be the least restrictive means, but it does have to be narrowly tailored to resolve that concern. And one of the conversations that Betsy and I have had about this particular case is, you know, there was no showing made that the surplus property in San Jose was needed for affordable housing. You know, what if there are other sites that are available for affordable housing? Then does that mean that the state still gets to come in and say how the city disposes of its surplus property, even if it's meeting its affordable housing needs under state law? You know, can they really justify that? So there's an additional aspect that I wanted to make sure that we touched on that. I don't know if Betsy has anything she wants to chime in and add there.
I think only say that I think this is where the if there's any sort of legal work to be done, it hopefully will be able to be done, at least on behalf of charter cities, in this last prong of the test. Is the statute narrowly tailored and reasonably related to the state legislative concern? In this case, in the housing case, the legislature says there aren't enough affordable housing sites. And then sort of no one looks below that to say, wait a minute, there's a state law in effect that requires cities and counties to identify affordable housing sites that they've been told they need to identify because it's their share of the housing that's needed in the state. So all cities and counties have done that. So wait a minute, if they've done that, how does there continue to be a shortage of affordable housing sites, right? So anyway, we'd like the courts to sort of look under perhaps these statements which support the statewide concern to see if the interference with local jurisdiction is actually reasonably related and, you know, narrowly tailored to their objective.
Thanks, Betsy. And I think if you look at that case in particular, the court really doesn't do that, which is interesting. It's a very short analysis pertaining to the reasonably tailored prong. Okay, sorry, Madeline. I know we've gone way over.
A couple people will raise their hands, so I'd love to give them an opportunity to ask those questions until we just, you know, really run out of time. But I think Jake raised his hand first, so I'll let you go, Jake.
Hi, thank you both for taking the time to talk to us. I was curious if you were familiar with the Huntington Beach case where they were challenging the California Values Act, because that has to do with police, and it also, I think, sort of runs against the procedural substantive distinction, because that's an act that is, you know, it's prohibitions, and it's an interesting case because I think morally it comes out right, but then for charter cities, it kind of throws that procedural substantive distinction out the window. And you know, but could be good with what people might be trying to do soon here in response to the murder of George Floyd and other problems with the police.
Sure, absolutely. Thanks, Jake. And for those who might not know, the California Values Act was the act passed by the state legislature to essentially say that local police departments, there are certain things local police departments cannot do in combination with federal immigration authorities. And so the city of Huntington Beach challenged that statute as it applied to them and said, you know, our police officers want to do these additional things to comply with the federal immigration authorities. And so you are interfering with our charter city authority over our police force, which is, specifically enumerated in subdivision B. And I agree with you. I think the court, they did get back to that substantive and procedural distinction. We were watching the case closely. It's an interesting case, but I think that it does fall along the lines of the Baggett case, where they essentially said, we're not telling you how to accomplish your local prerogatives. We're just saying on a statewide level, we've made these findings. And I think, you kind of acknowledge this, but there were some pretty good legislative findings underlying the California Values Act and the fact that, having local police departments take these additional steps to enforce federal immigration laws was undermining trust in the minority communities, and it was actually leading to harm, because when there isn't that trust, people won't show up, they won't be witnesses, they won't disclose things that are going on in their community. So I think in that case, it was pretty easy for the court to find a matter of statewide concern. And again, they weren't really telling them what to do with their police departments, but they were telling them not to do something. And so I think, it's kind of along the same lines. I think you can pick that apart a little bit. And you can see how telling a city not to do something could have just as much of an impact as telling them to do something. But that does seem to be a place where courts are willing to draw the line.
Okay, we got a couple more questions. I don't know if we'll have time for all of them, but Susanna, I think you raised your hand second.
Hi, thank you for talking to us today. I have a question about the Anderson case. The league filed an amicus brief for the case, and I was just curious on the thought process behind deciding to do that for the league, because it seems like the state is getting at a really important issue, which is affordable housing or housing in general. And I'm sure there's some cities that are doing their part, but there's other cities who are more reticent and are just not building housing, and definitely not affordable housing. And so was this a case where it was just the state is infringing so heavily on local government with telling them what to do with their land that the affordable housing issue wasn't that big of a concern? Or what was the thought process behind that?
That's a really, really great question, and something that we definitely had to take into consideration. We have a pretty robust process at the league for deciding to file amicus briefs in cases. We actually have a committee of 24 city attorneys from throughout the state of California that consider every case that is submitted to us for amicus assistance. And so we did take this to our legal advocacy committee, and those 24 city attorneys are geographically diverse. So they come from different regions of the state. But it's an important point, because I think that our members, our city members, are all over the map when it comes to affordable housing, how big of an issue that is in their community, what their priorities are for addressing affordable housing. And so when we decided to participate in this case, we did so on the grounds that we really thought that when you peeled back to the municipal affair involved in the Anderson case, again, this was property owned by the city that they were disposing of. So we really felt like that was a core municipal function of a charter city. And so we focused more on the municipal affair side of things than we did on refuting the matter of statewide concern. Our amicus brief didn't say anything about, you know, whether or not affordable housing is a matter of statewide concern, and that wasn't really the focus of our brief, because I think we felt like even if affordable housing is a matter of statewide concern, that's kind of a broad pronouncement, and that's ultimately what the court ended up doing in the case. But in our opinion, that's too broad. You have to look at it from the perspective of what is the municipal action that they're actually interfering with. And here, when we were talking specifically about city-owned property and the disposal of that property, you know, we were able to get behind the idea that that in and of itself is a municipal affair. And it's such an ingrained municipal affair that in order to override that, you would have to have a very specific articulation of the statewide concern. And so saying affordable housing is a matter of statewide concern, you know, some league members may agree with that, some league members may not, but even if that is the overriding concern, are you accomplishing that objective with this rule that requires cities to do a specific thing when they're disposing of their city-owned property? Or are there other means to achieving that goal?
Okay, I think Hiba next.
Hi, thank you so much for taking the time to talk to us. I just had a quick question. You mentioned, well, I was more so curious what the membership requirements are for cities to join the league, and why out of the 482 cities that are a part of it, why are there only 3 that are not?
It's another good question. So to join, it's a dues-based membership organization. So to join the league, all cities in California are eligible. You just have to pay dues to become a member. I actually think of the 3 that are non-members right now, I'm pretty sure that 2 of them, it's financial reasons why they are not members. And then I think from time to time, there has been over the years times where cities may feel like they're not sure if the league is representing their specific interests, and that may be a reason they decide not to participate in the league. But I think that's something that makes us especially cognizant of our role, and the fact that we are charged with speaking collectively on behalf of California cities. And so, you know, we don't get involved with every issue that involves cities in California, because we can't always speak with a collective voice. And we have our league board of directors, like our legal advocacy committee, is made of a geographically diverse set of city officials throughout the state of California, so that when we do decide to act, we do so by majority vote of our league board of directors, and that helps us to ensure that the actions that we're taking are representative of cities statewide.
Thank you.
And then I think we have one more question, and then we'll probably wrap it up. So Kelly, if you want to finish us off.
Hi, thank you both again for being with us today. Betsy was sort of, I think, mentioning that, you know, once we're at the statewide concern step, the procedure versus substance distinction, you know, becomes very salient. But, you know, I'm sort of brought back to 1L Civ Pro Erie Doctrine days, where I find that distinction to be sort of murky. And when I was reading the Anderson case, because of the court's explanation, I thought, okay, you know, I can buy that. But I imagined myself reading an opinion that comes the opposite conclusion and also buying that and seeing that it was more substance-based. So in what you see from the case law, are you finding consistency in when they find substance versus procedure? Or do you think it's kind of just more court du jour or maybe outcome determinative of what they're going to find that day?
I'll start and then Betsy can chime in, but I personally think it's pretty outcome determinative. Betsy, you want to chime in?
Yeah, I think it's very hard to it's certainly, it's impossible to make a rule, as was very well pointed out through the City of Huntington Beach case, in which the court spends some time saying, actually, we don't like procedural substantive distinctions, and we're not doing it on that basis. But then to really articulate what basis they're doing it on, so that you know in the future, whether this is a statute that should be challenged, could be challenged, how to challenge it. It's all very, I think, difficult to do. I think it is outcome determinative. I will say that I just read a quote from one of these cases, which at least sort of helps me understand what it sort of feels random. It says, when a court invalidates a charter city measure in favor of a conflicting state statute, the result does not necessarily rest on the conclusion that the subject matter of the former is not appropriate for municipal regulation. It doesn't necessarily rest on that. It means rather that under the historical circumstances presented, and that's what I want to emphasize here, under the historical circumstances presented, the state has a more substantial interest in the subject than the charter city. And I find that sentence sort of revealing and helpful for two reasons. One, when the moment in time in which the case is being decided is going to make a difference, And so when you read a quote from the Baggett versus Gates, the police case, which says, the purpose of the law, the state law, was to secure basic rights and protections to police officers who were thought unable to secure them for themselves. Now, that's probably not a sentence that would be written in a case, in an opinion today, right? So I think historical circumstances is important. And then the state has a more substantial interest in the subject than the charter city. And I think that goes to the question that was raised earlier about, wait a minute, affordable housing is really important, and not all cities are doing what they should be doing, right? And so, so maybe the state does have a more substantial interest. So I think that, for me, it doesn't allow me to predict, right, what a court's going to do, but I think it does, for me, help me kind of understand why these cases, sort of go up and down, and you can't really sort of understand them. I think perhaps except through, the historical circumstances that are presented. And I think that certainly applies to the Huntington Beach case. Here we are in these particular historical circumstances that gave rise to the Values Act and Huntington Beach's challenge to it.
Great. Thank you both.
I think that wraps up all of our questions. I don't know if you want to wrap it up, say a couple words, but we're well over.
Yeah, no, I'll just say I really appreciate you all being interested in this line of work. And if you ever want to reach out and talk about this or any other issue, please feel free to reach out to me. And just thanks for the opportunity to be here today.
Thank you.
Corrie, I can't thank you enough for participating. It was really, really excellent. It's always a great conversation, general law and charter city powers issues. I think that I totally agree with you that it's outcome determinative. I mean, it becomes so muddled. Anyway, thank you.
Yeah, we could talk for hours, days on this topic.